On Election Day, voters took a stand and rejected many of the candidates who threatened our democracy. Now, about a month later, the Supreme Court is considering a case that might endanger future elections. Justices heard arguments Wednesday in Moore v. Harper. It's a case based on the North Carolina legislature's efforts to redraw the state's congressional map. It's based on a fringe right-wing idea called the independent state legislature theory. OK, I'm using all the quotes because it's fringe. It's a fake theory. It removes state courts from the oversight of federal elections, and it gives unchecked power to state legislatures. Here is Justice Elena Kagan in this week's hearing. Take a listen to what she has to say.
This is a proposal that gets rid of the normal checks and balances on the way big governmental decisions are made in this country. And you might think that it gets rid of all those checks and balances at exactly the time when they are needed most.
I'm joined now by Kathay Feng. She is the National Redistricting Director for Common Cause, which has been fighting this case. Kathay, thank you so much for being here. Let's just start with this. Why do people need to pay attention to Moore v. Harper?
Thank you, Symone. I think the reason why Common Cause is fighting so hard to make sure that everyday people understand what's at stake with Moore v. Harper is that this is not just about who decides how lines are drawn for districts in North Carolina. This is fundamentally about our American democracy and whether the way that we think of our American democracy, having checks and balances built in, the three branches of government, essentially checking each one, and no one branch of government having absolute power, whether that still is the fundamental core of our democracy. Or do we say that one branch, the legislature, gets absolute power?
It seems quite strange to even think that there's a group of people that will believe that the latter is what we should be doing. Can you just walk us through why specifically the independent state legislature theory is actually central to this case? Because some people might say, oh, this is really just about redistricting.
Sure. I think in order to understand how we got here, you have to understand what the underlying case was about. So this was a redistricting case coming out of North Carolina, where the North Carolina state legislature, controlled by one party, decided that they were going to draw congressional lines that skewed in favor of their party. They wanted to rig the outcome of those elections. And when we challenged that, us, Common Cause, and the Southern Coalition for Social Justice challenged that, the court said no. The court said our state constitution prohibits rigging elections so that voters have no choice. They relied on a state constitutional clause called the Free Elections Clause, as well as other clauses, and they said no. There was no place for the North Carolina legislature to appeal that decision. They didn't like having their maps redrawn by the state courts in a fair way that resulted in a 7-7 result for Democrats and Republicans, an even Steven map. And so the only way that they could challenge it was to go all the way to the Supreme Court and insist that the state courts are not the boss of me, right? So they came up with this crazy theory. It's called the ISLT, but I like to call it the BSLT because it is full of BS.
Yes,
right?
Kathay. Yes,
they want to claim
that
the Constitution, the Constitution doesn't have any way of restraining or constraining the state legislature when it comes to passing laws around federal elections. And they claim by looking at that little clause in isolation, they want to throw out 230 years of precedent. They want to throw out what our framers understood. They want to throw out the history and what every single state constitution enshrines, which is we've got three branches of government and each one has a check and balance on the other. They want to throw out the state courts and the state constitution because they don't want anybody to be the boss of me. And it's the only way they can get around to getting rid of the district maps that the state court said that they had to follow.
I know it took a minute, but I'm glad, Kathay, that you explained that, because I think there were a lot of folks wondering, how did this even get up to the Supreme Court? But it is no coincidence to me that it is North Carolina's legislature that wants state courts out of the equation when it comes to drawing congressional maps, because I remember about 3 years ago when a 3-judge panel threw out the state's Republican map And it accused the legislature of acting with what they called surgical precision in a highly partisan way, particularly targeting black voters, or disadvantaging black voters. So what did the justices have to say during oral arguments, if you can, quickly?
In the Supreme Court, the justices, one by one, asked really hard questions. And this court oral arguments process took 3 hours, which is about 3 times longer than usual, because they were really asking, where are you getting this BSLT from? Where do you find any kind of precedent or any basis for it? And again, I think the questions revealed that there was no basis for arguing that the legislature should be able to act without anybody overseeing it. And so I think really what we're down to is whether we're willing to essentially nuclear bomb the House just because we don't like the color of the paint on the walls.
I guess last question, Kathay. It sounds like it's either or, but do you think that the justices could come up with some middle ground to be found in this case? And if so, do you have a theory on what that could look like?
Yeah, sure. I actually think if you move away from the crazy ISLT and you say, all right, we don't take state courts out of the process of reviewing what state legislatures do when it comes to passing federal election laws. But we do say from time to time, if there's a real problem, we can review what that state court decides, that it does create a potential area for review that would have to be very differential to those courts. But maybe we would want to make sure that nothing that state court does is out of line with the federal Constitution. That might be the compromise.
I'm scared. I'm telling you, Kathay, I'm scared about that because let me just say, North Carolina, honey, they have been doing nefarious things in that state legislature for a very long time. Kathay Feng, thank you very, very much for breaking it down and all your expertise. Appreciate your time.
Thank you so much. And happy birthday, Symone.
Thank you. Thank you.